Lordship's leave to mention a Section 34 application where we are appearing to the respondent. Mr. Shaturu Banerjee was arguing for the petitioner. Lord, I'm not seeking for hearing of the Section 34 application, but Lord, there is one of the claims in that matter was something, Lord, we were seeking relegation back to the arbitrator, which your Lordship now has the jurisdiction to send it back for correction in view of the fact that there is inadequate evidence. Lord, Supreme Court says it can be either be done by your Lordship or at our instance on an application made by us. So, Lord, we've made that application. We only seek your Lordship places it in your Lordship's list on any day convenient to your Lordship, so that if your Lordship so feels, it may be sent back that one claim.
My Lord, I am appearing for the petitioner in Section 34. Lordship will remember I was arguing, and on the one point that I have argued till now, they are agreeable to send it back for that issue to the arbitral tribunal. Now, my 34 is pending. So if now I feel that the one point that I've argued, they've agreed. If I will argue the others, they will also agree to it.
May not be so.
So my Lord keeps the 34 along with his application.
It's a wonderful submission,
my 34 has to be heard. My 34 may be kept with his application. I have no issues with that.
I like the confidence, Mr. Manager.
After this application, my Lord, I wasn't having so much, but after this application, I have, my Lord. So keeps it. Both of them, Lordship keeps it anyway.
I direct our application to appear in your Lordship's list, whatever as new motion.
Along with my Section 34.
Why don't we just hear the entire 34?
Lordship may hear out the Section 34, but
do piecemeal.
No, Lord. Now, Lord, so far as this particular claim is concerned, Lord, the Supreme Court, as your Lordship knows, says that if the parties feel of your Lordship's feel,
but he doesn't feel. Yes.
No, he may not feel. I am not seeking his indulgence or his concession. But if we, Lord, the award holder feels that there is inadequate evidence and it may be difficult to sustain it, we may apply before your Lordship, or your Lordship may, of your Lordship's own, direct that the matter be sent
award
back.
Award is of which year?
Pardon, Lord?
Award is of which year? This award?
2024 award, Lord.
My Lord, what is the difficulty?
One award on account of loss of business. We felt, Lord, that this award, Lord.
I have no issues.
We
Let
made
the 34 also appear, my Lord.
We made a formal application for the matter to be sent back.
My Lord, it cannot be sent back piecemeal, my Lord, without hearing the 34. Had there been no 34,
perhaps my learned friend has not read the judgment.
Well, I have read it. I have read it, my Lord. When my 34 is pending, that is not the facts of the case.
But Lord, the Supreme Court itself says that if it's sent back, the Section 34 remains adjourned for the time being. That's what the Supreme Court exactly
says. That cannot be of the simple reason.
Section 4 also says that.
My Lord, that cannot be of the simple reason, my Lord, of the fact that I was arguing. That is a case where it was not being argued.
I understand my learned friend's brief is to oppose, but Lord, kindly keep it in the Lordship.
No, there is no question of opposing, my Lord. Let both appear.
Concerned, I'm not going to just allow the application.
No, Lordship will hear it, but Lord, kindly keep it in your Lordship's list as new motion.
List new motion.
It's a new application, Lord. It's not appearing in your Lordship's list.
We'll see.
It's a fresh application.
My Lord, kindly keeps it with the 34.
34, I'll keep it with the 34.
Yes, my Lord.
Yes.
Your Lordship, Section 34 appears a little way down in the list because the new motions are heard initially.
We are hearing 34
now. 34 is already there in the list, my Lord. If this appears, we can hear it out together.
Because, Lord, if your Lordship hears this and your Lordship feels that this is a matter to be relegated back to a tribunal, Lord, the law as it now stands in terms of the section.
Do it after exchange of affidavit. It is not going to just happen.
No, Lordship may do that.
So the amount of time which we are going to waste in deciding this application, probably why not hear the 34?
Yes. Lordship may hear out the 34, but on the balance claims. That is what Supreme Court.
Of course, this is
because if the parties feel that one claim can be justified and can be embellished by further evidence which the arbitrator has missed out, that can be sent back.
We'll see both the.
This is to save the award.
Keeps both, Malord.
The entire purpose is to save the award.
We'll see both.
Grateful, Malord. Grateful.
Listed matter item number 1. This is my application. At this stage, I was only praying for leave to serve the copy of this application. On the last day when the matter was taken up, Lordship has asked us to bring the copy of the earlier application. Lordship's order which has not been complied with is at page number 13 of the IA, which is on board, order dated 18 June 2026. Now kindly comes to page 14, last paragraph. Page 14, last paragraph. Today I was only praying for Lordship may give us leave to serve because this is
No,
application.
no, I'm going to dismiss.
Kindly see, I will try to persuade your Lordship otherwise.
Nothing.
Kindly come to page 14, last paragraph.
Yes.
Lordship order is accordingly the award debtor is directed to pay the award holder the balance amount which remains payable under the award after giving due credit to the amount released by the registrar original side together with interest. So, Mala,
In the event the award debtor fails to make the balance payment within the aforesaid period, the
Yes.
award holder shall be entitled to take appropriate steps
yes,
in accordance with law
Correct.
for enforcement and recovery of the same.
yes. Now, according to us, the chart we have annexed.
Contempt is not the.
I know I have
I'm
judgment.
sorry.
No, Lordship will do that, but kindly give me chance to place two judgments of the Honorable Apex Court, which
Place all the judgments and I'll dismiss with cost if you place the judgment.
Mala, just hear me once, Mala,
I'll hear
before that.
you, I'll dismiss with cost.
Mala, those judgments say that even if there is an amount due not
This is
payable.
my judgment. I will see the contempt.
No,
I don't have to look into the Supreme Court. Give it.
copy.
And I'm telling you, I'm dismissing it with cost.
No, Mala, my duty is to Lordship.
Show me whatever you want to show me. You can't read the judgment as a contempt.
Mala,
please.
Mala,
There
the
is no contempt.
copies are
You
not.
have your remedies to recover the money. This is not the remedy.
Mala, I've got my soft copy. The hard copies are not there. May I come back in the coming with
No,
the
no,
hard
I'll decide it today.
copy? Mala, I've got my soft copy. Mala.
I'm going to decide with cost in this matter. This is not done. My orders can't be interpreted the way you want to interpret.
Mala, may I hand over the soft copy? If
Actually, sometimes I feel that being benevolent to the client actually is counterproductive.
No, Lordship. I
It's
know what is
counterproductive.
Lordship, Lordship, what is going through your Lordship mind. If there are two remedies, Mala, the
Sir,
Honorable Apex Court say that
You have recovered the money.
Not full.
I know not fully. Only the balance is 5 lakh something amount.
5 crore something. Yes.
You have got most of it. He has made payment after on the 17th. The last payment is also made. There's no contempt made out. You have a remedy to recover the money. Go and
By
recover the money.
execution.
Yes.
I know that. That is why I also told this to my clients
Please
when they
tell
came
them-
up with the contempt.
Tell them not to file this contempt.
Mala, then may I
Withdraw this
take
contempt.
may I take instruction on this and come back next
Come
week?
back.
Mala, only prayer I was
Tell
making.
them the
I
court
followed. I
is
followed.
not inclined at all.
I also told them the same thing. That why have you filed contempt?
This is I feel that this is absolutely not
Abuse
being-
of process.
abuse of process, not being fair to the court. And this is the second time. Mind it.
Lordship, only prayer I was making.
For the council.
Mala, only prayer I was making. Lordship, if your Lordship,
Your council had got this matter listed.
Mala, that
How he got
I
the
know
matter?
that he has tendered his apology.
Then he files the contempt.
I said on that. Lordship, may I only make one humble prayer? Lordship, may kindly keeps it on 7th of the coming month. 7th Monday or 9th, my lord, 7th or 9th. Whichever date is convenient. If it Lordship allows 7th or 9th of September.
You're not there on second?
Second, first half I will not be here, my lord.
All right, 7th.
7th. Great. I will ask my client to persuade my client.
No, persuade. You
I
must be
also-
given the suggestion.
I told
What
the
if
same.
the clients don't dictate you.
My lord, they come up. They
You tell
come.
the client
They come after it is filed.
what the clients are going through.
My
They
lord,
put it on Claude.
after
And they
the
get the
after the petition is filed, then they come to us, my lord. Sometimes it is one of that case. I also told
he
them.
has been pursuing this matter from day one.
No, that my lord, because of his enthusiasm, my lord, he is so young.
Enthusiasm shouldn't mean abuse of process of law.
Restoration application I did not do.
My lords, this is my application for restoration and recalling of the order dated 10 June 2026, passed by my lords. My lords, on that day, the item was running in the monthly list as item number 52. And when the matter was called up, unfortunately, the learned advocate engaged was in another court, my lords, and that's why the matter could not be attended to. My lords, I'm praying that the matter be listed on some specific day so that it can be argued, my lords. It is a Section 9 application that was filed at my behest, my lords, and this is my restoration application.
This was dismissed on
My lords, 10th June 2026.
Take down.
My lords will find that order on page 7, my lords.
This is an application filed by the petitioner for restoring APCOM number 156 of 2026, which was dismissed for default by this court by the order dated 10th June 2026. Full stop. For the reasons stated in the present application and the argument advanced by the learned counsel for the petitioner, the application is allowed. APCOM number so and so is restored to its original position.
Grateful, my lords.
After 2 weeks. After 2 weeks. After 3 weeks. After 3 weeks.
Number 3, my lord, I appear for the petition.
Yes, sir.
This is that section 29A application.
Yes.
When, my lord, the two arbitrators signed, the third didn't. My lord, kindly dispose of the application, my lord, keeping all points open because we have filed a section 34 now. These grounds have been taken in section 34.
No question of leaving all points open. Either you
Because this is the
Why-
point that, this is the point, my lord,
that
that,
is available in section 34.
so
if
we
it is
have,
available.
because later on,
You are just withdrawing the application, right?
Lord.
You are withdrawing the application.
my lord, kindly keep all points open because withdrawal of the application, later on, my lord, it can be contended in 1001 arguments can be advanced on that. I don't want to be technically, my lord,
This is, Mr. Kar, this is just a 29A
Yes.
application. So this
Yes,
is extension
but-
of time.
Yes.
but my lord, the grounds that has been taken with regard to the haste and all those points,
Right.
those are taken, my lord, in a section 34 application.
That's
Lord, I don't want to be technically mud with the point that, Lord, this was raised but not argued, withdrawn. Lord, 1001 points can be taken. Lord, if your lordships, Lord, kindly, Lord, one word, whichever way it says, that, Lord, the points are kept open. That's all.
So I can say that the petitioner is withdrawing the present application with all points to be kept open in
Absolutely.
appropriate proceedings.
No, no,
That are available to him.
So available.
That are available to him in law. It's section 34. This is a ground.
In accordance with law, my lords. In accordance.
My lord, he's filed a section 34, which means he's accepting his award.
The present petition. The petitioner seeks to withdraw the present petition with liberty to keep all legal points open to be adjudicated in accordance with law before the appropriate
Deeply obliged. Deeply obliged, my lords.
same
Great.
dismissed as withdrawn with the liberty of state.
Oh.
Great.
Much obliged. Your Lordship.
And now for my lord, I appear for the petition. My lord. My section 29A application, my lord. What has happened, my lord, the arbitrator was appointed on 21st November 2024. But thereafter, the pleadings were completed on 13th August 2025.
Who's on the other side?
But I have served on the Eastern Railway itself. The affidavit of service is on record. On 18th of December 2025, the award was reserved, but however, the award was not passed. Thereafter, the learned arbitrator has been elevated to the Honorable Judge of this Honorable Court.
An application.
But under section 29A6, I will kindly take section 29A6 once. If it is not satisfied, then I'll take. But in section 29A6, that
Yes, arbitrator can be appointed,
Yes,
but
ma'am.
then the ground has to be shown.
yes, ma'am. During the pendency of this application, this elevation has happened, and I am filing a supplementary affidavit to bring on record, my lord, that what has happened, my lord. On the last occasion, I had taken leave, and my lord, section. May I read, my lord? While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all the arbitrators, and if one or all the arbitrators are substituted, the arbitral proceedings shall
The reasons
continue.
are entirely different, sir. This can't be. Provided the wording is-
During the adjudication of section 29A4, this can be done. Now, my lord, the circumstances are, that has been that the arbitrator is not. I cannot extend the mandate without substitution. I cannot. And my lord would kindly see the age of the petitioner who is fighting, my lord. This matter is going on from 2021, my lord.
Read the proviso.
Yes, my lord.
Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for the reasons attributable to the arbitral tribunal, then it may, under reduction of fees by not exceeding 5%, so and so, provided further that where there's an application is pending, the mandate shall continue till the disposal, provided also that the arbitrator shall be given liberty, but before fees, the extension of the period referred to 4 may be on the application of the parties. While extending the referred to 4, it shall be open to the court. This is all when the delay is there.
Yes, my lord.
There has to be a delay attributable to
The award was pending for
arbitrator.
8 months.
Move a section 14
But there is no arbitrator, so I can not move.
or without
I understand.
application. I can't substitute. Substitution application has to be there.
But this has been done in a previous section 29A matter, my lord. But my lord, kindly consider
I
the
will not
age.
do it.
Kindly consider, my lord.
I will not do it.
Very well, my lord. Then I have to. If I do not, my lord, then I have to appoint another new arbitrator, my lord. The proceedings will start from the afresh. That is the problem, my lord.
It will.
But in a similar circumstances, the Supreme Court has ordered. I can give the judgment. My lord, kindly grant me
Next week.
next week, my lord. My lord, kindly let me file a supplementary affidavit at least.
For what?
But bringing on record that during the pendency, this elevation has happened.
Next week you come up with.
Very
So, keep it after 2 weeks.
Five.
My lord, this, my lord, as it fell from my lord, I had personally had a word with her. She said that, my lord, 2 months, my lord, she will be able to pass the award.
As I beg to appear for the respondents, madam. We have no objection if any extension is granted by this honorable court.
When is
My lord,
last extension given?
Yes, last section.
my lord, last extension, my lord, was granted on 18th of May 2026, my lord, which expired on 17th of August 2026, my lord.
Mr. Banerjee.
Page 71.
66.
My lord, lordship, my lord, I have as usual prepared a list of dates. My lord, lordship will find it, my lord, at the very beginning.
71, my lord.
71.
List of dates. Where's the list?
List.
Yes, my lord. My
Yes.
lord, that's the, I think the 4th page. my lord. If your lordship sees from the beginning, my lord, it's not paginated.
Page
Lordship will see second last date, my lord, is 18th of May 2026, on
Yes,
which
not-
lordship.
He has not handed over any. You have a copy. They all have their tabs.
Oh, my lord, but this is part of the, my lord, petition itself, my lord, the list of dates, my lord.
My lord, 71, my lord.
Last program is page 71.
Yes, tell me.
My
My
lord,
lord,
that
this was the last extension pass, my lord, on 18th of May 2026,
Yes.
which got expired on 17th of August 2026, my lord.
Take down. An application filed by the petitioner. Learned counsel for the petition, Mr. Banerjee submits that the sole arbitrator was appointed by this court by order dated 75/2023 to adjudicate the dispute between the parties.
Yes.
The pleadings were completed on 12/10/2020. With the consent of the parties,
Got it.
the mandate was extended by 6 months till 21/3/2025. Thereafter, while order dated 3/3/2025, 10/12/2025, and 18/5/2025.
2026, my lord. Last one is 2026.
2026, the mandate of the arbitral tribunal was extended for a period of 8 months, 4 months, and 3 months, respectively. Learned counsel for the respondent states that he has no objection to the present application, the extension of the mandate of the committee. Full stop. This court notes that though the arbitral proceedings had reached an advanced stage and the matter stood reserved for award on 21/9/2025, the arbitral award has yet not been pronounced despite extension granted by this court while order dated 10/12/2025, 18/5/2026. full stop. The mandate of the appeal tribunal has expired, comma. Thus, the petitioner has preferred the present application. Considering the advanced stage of the arbitral proceedings, and in order to enable culmination of the arbitral process, this court deems it appropriate to extend the mandate of the arbitral tribunal for a further period of
2 months.
2 months, my lord. 2 months. I had a word with her.
My lord, my solicitor. My lord,
No, my lord, I had a word with her, my lord. She said 2 months. So I cannot, my lord, say something which she has not told me, since my lord asked me to have a word with her.
I give 3 months.
Yes.
Whatever, my lord. I can only, my lord, inform my lord what she said.
3 months as a last opportunity.
Yes. Grateful.
Grateful.
It is made clear that the learned arbitrator, if the learned arbitrator fails to publish the award
Last section. Yes.
within the extended time
Last
period, comma, this court will be constrained to take appropriate consequential steps in accordance with law. With the aforesaid direction, the present petition stands disposed.
Grateful, man.
Grateful, man. Grateful, man.
Grateful, man.
And now 6.
Wait, please, Your Lordship. But a Friday kind of a matter, my lord. 29A extension.
Well, we are not opposing it.
Lordship.
Very fact-heavy matter, my lord. We understand it's required.
Has any extension before?
No, my lord.
First extension.
First extension. Lord, I'm
6 months was extended, my lord.
Just give me the dates. When was the arbitrator appointed?
Lordship, the appointment was on 23rd September 2022.
And pleadings completed?
Pleadings company. This is cross.
When?
My lord, 12th of March 2025, my lord.
First extension?
At page 28, your lordship.
6 months extension, my lord. 29/7/2026. That's page 25.
29/7/20.
29/7/2026, my lord.
This is still 29/7.
Your lordship will find it at page 28. It's written extension. The time is still, my lord, 4th of
4th
September.
September.
4th September. my
It's
lord.
going to
4th
expire on 4th of September.
The last paragraph at page 26. my lord. Beautiful.
4th September. Take down. Same. This court-wide order dated 23/9/2022, comma, appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 12/3/2025. Full stop. Thereafter, with the consent of the parties, the mandate of the learned sole arbitrator was extended till 4th September 2026. Full stop. Upon consideration of the material placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. The mandate of the arbitral tribunal is further extended for a period of
1 year. my lord.
1 year.
1 year.
It's a very fact-heavy matter.
1 year from today.
Grateful, my lord.
Deep
Extremely
The
grateful.
learned arbitrator is requested to complete the arbitral proceedings and publish the award within the extended time period. The aforesaid direction to present petition stands disposed.
Deeply obliged. my lord. May the affidavit of service and notice of motion be kept on record.
Affidavit of service and notice of motion are taken on record.
Very deeply obliged.
Since no affidavit is being used, my lord, all allegations will be denied.
There's no allegation.
There are.
Deeply
Grateful, my
obliged. my
lord.
lord.
7.
That's item 7. I appear for the petition of Lords. It's 29A, Lord. Seeking extension. Second extension, Lord. The first extension was granted on 9th June 25 by this
Okay.
Honorable Court.
What's your name?
That's 9th June 25. Your Lordship would find at page Avinash Trivedi, Lords.
Yes, Mr. Trivedi.
An extra H. The first extension was granted, wherein in this what had happened was the presiding arbitrator, as originally constituted tribunal, expired. We moved, Lords, in the interagnum, he expired, Lords, and this Honorable Court, while granting extension, appointed the presiding arbitrator, Lords. That's the order of 9th June on page 58 of the file. Honorable Justice Alok Chakraborty was appointed as the presiding arbitrator, and the mandate was extended by a year. Para 4 and 5, Lords. Now, post that, Lords, I have concluded my arguments. I appear for the claimant, and it was listed for respondent's argument tomorrow, Lords. The mandate expired on 29th July 2026.
My lord, I appear on advance notice. In fact, my learned friend has been gracious enough to spoil my sweet dreams and serve me at late at night. Your lordship, we are a government of India undertaking, and in fact, the main issue was maintainability. That has been decided. I recently got the order in July, though it was done. I have much to say. I'm objecting to this extension. I'm requesting a week's time, your lordship. I will file it. Your lordship, that it is not maintainable. There's a dissenting judgment. There's a dissenting judgment of the Honorable Tribunal, and item 41 and 107. I've been troubling your lordship online as well as offline here. So that's been on my lord's board. In fact, that's listed today. So all the grounds have been taken up there. In fact, there's a dissenting award that the matter is not maintainable. Against a third party can't file a claim against me, your lordship. That's the main issue. So on that, I need to object, your lordship, and
the extension was granted earlier.
Your lordship,
Consent, my lords.
let me speak, Mr. Trivedi. That was on misrepresentation and fraud, because in the pleadings they had specifically said that this party had taken over the other party. While evidences were ongoing and the arguments happened is when this came to light. And we immediately in November 25, your lordship, that issue has been framed and that order is not on record. They've not filed it. In fact, they should have been transparent with your lordship. So during the course of the proceedings, it's come to light that they have actually lied on the claim also. So that's why, your lordship, we are objecting to this extension today. And 9 November 2025 order that should have been annexed, where your lordship would have had the opportunity to review.
You have a copy.
Your lordship, your lordship, can I hand off?
You don't have a hard copy.
Your lordship, I can just get it if your lordship passes over. I will make the necessary arrangements.
Monday. Come back.
Please, your lordship.
Monday.
Please.
Deeply obliged.
Grateful.
Motion section 11, item number 8.
I beg to appear for the petitioner. My lord, as per the liberty granted by your lordship, I am filing my supplementary affidavit.
The copy may be served on me.
My lord, this supplementary affidavit only has 3 dates which they are aware of, and they have the copies themselves. However, I shall, sir.
Let me go through
Readings have to be
It
completed.
is the same deeds. There were 4 days that were
That's
attacked.
right, but whatever it is, readings have to be completed. You have to give a copy.
Okay, my.
I give it.
Even if they have everything, still you have to give a copy.
They are only a party to it.
That's all right.
the reason.
Still
There
you
was
have
no
to give a
direct-
copy.
I shall serve them a copy right now.
Even if it is his document, still you have to give it to him.
Yes.
If you are placing on record.
So let them serve a copy. I'll use an opposition to that.
Opposition to.
I have not got
No,
it yet.
this is just
The
the
copy
document.
first.
My lord, there were 4 deeds, unregistered deeds, which were attached to the main petition, my lord. However, 3 of them were registered. The first one, which was different, the clause regarding the MOU was different. That deed was not registered, my lord. The 3 deeds which were registered had the same clause where they were relying on the MOU.
But may I come back with instructions? Kindly grants me a short time.
My lord, this is just the document, my lord.
Let him come back. You are giving him a copy right now in the court. And that too very,
My
very
lord, this is just
reluctantly you
a
are giving a copy.
document which they are party and they have a copy, and there is nothing extra in the supplementary affidavit apart
Are
from
you
the
sup-
dates, my lord.
Just answer my question. Are you supposed to give all the pleadings to the other side or not if you're filing it in the court? Are you or you're not? With such reluctance, you're giving a copy.
I shall, my lord, let the matter be fixed next week anytime.
Monday. Supplementary affidavit is taken on record. A copy of the same has been provided to the learned counsel for the respondent who seeks and is granted time to go through the same list on Wednesday. Very good. Come back on Wednesday.
Lordship.
Wednesday.
Very well, Lordship. Great.
I'm grateful, Your Lordship.
I appear for the respondent.
Fine.
Sorry.
Lordship,
On the last occasion, my lord, my learned friend had submitted that the arbitrator has recused the matter from the matter. That is why, my lord, there was nothing for me to oppose. Otherwise, I was opposing. So he was given liberty to, my lord, file a supplementary affidavit to bring on record. But my lord, now we have not received any instructions or any communication from the arbitrator of his recusal.
Lordship, this is section 14 matter, Lordship. In 2024 October, arbitrator was appointed, but net result is 0. Thereafter, in February 2026, I filed this application. Several opportunities, Lordship, given to the arbitrator, whatever. But still, after giving this order by Honorable Court, the arbitrator is not giving any order. Lordship, kindly see, I have
That was
communicated.
not the premise on
Yes.
last occasion that.
Yes, I am submitting to the Honorable Court, Lordship. Kindly see the conduct.
Last time you said that the learned
Yes.
arbitrator has resigned from the present arbitral proceeding, though no official communication to that effect has been received by, except for a message sent by the arbitrator on his phone.
Lordship, the message is there, and I have communicated the on court's order and requested him personally, as well as through WhatsApp, as well as through email. He sitting tight, and this situation both of us is facing for last 2 years. Lordship, kindly pass the order, Lordship. What I can do? He have communicated me WhatsApp. Lordship, see, kindly communicate to the Honorable Court, I will refuse. Thereafter, nothing. Then Lordship pass the order. Whatever order be passed by Honorable Tribunal, kindly make a supplementary affidavit and file to me.
I'm not aware what email he is relying upon.
What I can do?
No, but you made a statement last time, sir.
Yes.
That he has resigned and he has sent a mail. Where is that mail?
No, I have never said. I have, Lordship, kindly see the order. Lordship, in the order, Lordship recorded in WhatsApp, it had been communicated, he will refuse. In cell phone, Lordship, it is cell phone record. But if don't write any order, how I can communicate what more?
Have you read the last order? Mr. Sahu,
Yes, my lord.
Yes,
I am.
Lordship. In cell
read
phone,
the last
Lordship.
order. You are saying that you have received a message
Yes,
from the where has he resigned in the message, sir?
Lordship?
Where has he resigned?
Lordship,
Where is the resignation?
so you can tell the judge that I have decided to refuse. Oh, this is the thing I have communicated, because early in the late evening of the last date of hearing, he communicated me. So that's why I have communicated, and thereafter, Lordship, kindly see my email. I have expressively communicated that if kindly give your order so that I can make supplementary affidavit and give the Honorable Court on the returnable date. What a advocate can do, Lordship, I don't know. I am trying, and they are also participating in the tribunal, but net result is 0. So I need.
My learned senior friend is also appearing before the tribunal.
Yes.
After filing of this application, 6 months time was extended. Thereafter, Section 16 order was passed. He had taken order for rejoinder as well. That was my grounds for opposing.
And Lordship,
but on the last occasion, my learned senior friend had come and
no
submitted
extension
to your
was
lordship
required
that he has
because
recused.
pleading was not
In that matter, I could not have any further objection. That is why I did not proceed with the matter on my
No,
objection.
Lordship have given them twice opportunity to file affidavit in opposition.
In view of
Lordship, what can I do, Lordship?
What can you do? You make a statement. You're supposed to file a supplementary affidavit. Where's your affidavit?
Lordship, without the order of the Honorable Tribunal,
whatever your communication is, at least you'll put it on record, or you won't put it on record.
That thing I need to do.
Then Learned counsel for petitioner seeks and is granted further time of 3 weeks to put his supplementary affidavit, to file a supplementary affidavit in terms of the order dated. In terms of the order date, 5th August 2020. Yeah. That's after 6.
Your Lordship, in item 10, I am for the petitioner. I was to file my affidavit and reply, Your Lordship. I'm seeking 2 days' time. Today it will be affirmed. If thereafter, subject to Your Lordship's convenience, the matter may be kept.
Affidavit of opposition you have filed.
Yes, that was on.
It's on record, no? Learned
Last occasion, it was not on record.
Just check because it's not record. Learned counsel for the petitioner seeks and is granted further time of 1 week to file her reply to the affidavit in opposition. List after. This is section 11, right?
Your Lordship, section 11.
After 2 weeks.
Grateful, Your Lordship.
And 11.
Item 11, my lord, there was a direction for paper publication, my lord. It has been published, my lord. The paper cutout has not yet been received
Learned
by us.
counsel for the petitioner seeks and is granted further time of 2 weeks. Comply with the order dated 12th August 2026. Weeks.
Itu naam kya? 12.
Well, my lord, I appear for the petition, my lord. I apologize, my lord. I could not affirm the affidavit in reply, my lord. Kindly grant me last opportunity of 10 days time. I'll file my affidavit in reply. On the last, my learned friend has filed the opposition. I'm praying for 10.
What is your name?
29 July, my lord.
What's your name?
What's the name?
Your name.
Mine? Sujit Banerjee, my lord.
Sunil?
Yes, my lord.
What's your name?
Sujit Banerjee, my lord.
Last time also you took time.
Last opportunity, my lord. I'm praying for 10 days time, my lord. 10 days time only, my lord. The petitioner who will affirm, my lord, is not in a medical condition. His health was down, my lord. That is why he could not come to affirm. I assure, my lord, kindly grant me 10 days time. It will be affirmed, my lord.
When was the affidavit of opposition filed?
Affidavit in opposition, my lord, was filed
on 29 July, my lord. On the last
occasion, my lord. We served them with an advance copy because the matter had come up, my lord. We filed it on the last.
Petitioner seeks and is granted for the time of 1 week. File as affidavit. Reply to the affidavit and opposition.
My lord has kept it on, my lord, on.
List after 2 weeks.
Grateful to you.
deep acknowledgement. Deep.
And now 13.
But I beg to appear on behalf of the respondent numbers 2, 3, and 4.
And I am pursuant to my lord, since the cause title was amended, it has been served upon to the respondent number 3. And this is the affidavit of sale.
I have appeared.
There's a dispute with regard to a partnership.
2, 3, and 4.
Partnership agreement. Well,
I would like to file an affidavit in opposition to this.
okay, sir.
There are a lot of suppression of facts. So, I would like to file my opposition. So,
why you are denying the agreement?
No. So far as the appointment of an arbitrator, my lord, because there is a clause. That is
Go before the arbitrator, file everything.
what I'm saying, my lord. It should come before your lordship, my lord. What are those things which has been supplied, at least through my opposition?
Why?
That is, my lord,
Why?
it is a partnership agreement whereby,
So
my lord,
whatever your claims are, whatever the issues are, go before the arbitrator.
but I want to bring it in on record because whether your lordship will see, my lord, because
Section 11, I am only seeing the arbitration clause and
amendments
the
which have been made, so far as my learned friend, my lord, those are all misleading.
go before the arbitrator. All your points are left open. I'm not deciding on anything.
I go down to your lord.
All your points are left open.
My lord,
Clause 27, page 25 is the
I will
arbitration.
kindly record that so that
All points are absolutely. I'll record that. All points regarding
All points should be
arbitrability,
kept open.
maintainability, claim, counterclaim, whatever. All issues will be left open to the arbitrator.
Page 25, man.
Yes, page 25 is
The arbitration clause, my lord. All disputes and differences whatsoever arising between the parties and personal affairs would be appointed by the parties hereto by an arbitrator. Last portion, my lord, of the page 25.
paragraph 27.
Paragraph 27. Page 25, paragraph
so
27.
you want single arbitrator or three?
Single arbitrator because
Junior member of the bar.
that lordship will decide.
That's a claim.
I cannot dictate the court by we cannot. It's upon my lord to decide.
Where's section 21?
Section 21, no, that's not.
Page?
Hello. Section 21, page 28. Page 28.
One of the partner has expired. That should be there. Because there were all total 6 of them. One has expired.
So at the legal heirs.
Shubhoshri Nandan is no more. That I have information, my lord, and upon instruction, my lord, I am submitting. So
if
far
that
as
is the case, then change the cause title at the legal heirs.
Shubhoshri Nandan has, my lord, upon instruction, my lord, that she is no more.
So verify that. We'll keep it on Monday. Find out.
They cannot. I have been
Monday. Keep it for Monday.
But Shubhoshri Nandan is not a party to the proceedings, my lord.
Not a party.
Not a party.
One of the partner to the. She is not a party.
Not a party to the proceedings, my lord. My lord takes up the cause title of the application, my lord.
She is not a party.
She is not a party. Now the partners are Aparna Acharya, Susmita Pal, K. Raman.
You appear for Susmita Pal. And you appear for 234.
Section 21 notice is page 28 and the reply is at page 50. Reply to the section 21 issued by respondent number 1.
Page?
Page 28 is my question.
Yes, reply
under
page.
section 21.
Reply.
And reply at page 50, my lord. Reply issued by respondent number 1, Susmita Pal. And I have categorically mentioned in paragraph page 30 that the Shubhoshri Nandan has expired.
Your present petition has been filed under section 11, 6 of the Arbitration and Compensation Act, seeking appointment of arbitral tribunal to adjudicate the dispute and differences which have arisen between the parties in terms of the partnership deed dated 18th May 2014. 18th, it's May or 18th May, right?
18th May 2014, madam. Page 12.
Learned counsel appearing on behalf of the petitioner submits that the petitioner from other respondents and one late Shubhoshri Nandan jointly entered into the partnership deed dated 18/4/2014 for carrying out the business of running a school in the name of inverted comma डालना Emily School with Crush. Page 20. It is further submitted that under the terms of the partnership deed, the partnership was agreed to commence with effect from 1/4/2014 and continue till 2035. Full stop. The day-to-day affairs and management of the partnership business were entrusted to respond number 2. Full stop. Learned Counsel further submits that one of the partners named Subhashri Nandan expired on 1/5/2021. Full stop. However, despite the demise of the said partner, no steps were taken by the remaining partner for reconstitution of the partnership firm. Partnership deed. Full stop. Partnership firm. Reconstitution of the partnership firm. Full stop. It is alleged that thereafter the affairs of the partnership business was conducted unilaterally without the consent and involvement of the other member. The petitioner has alleged various financial irregularities and mismanagement in the affair of the partnership firm, including embezzlement of funds, improper maintenance of books of accounts, and exclusion of the petitioner from the management and functioning of the firm, of the partnership firm. Full stop. It is further contended that the petitioner that he had invoked the arbitration clause as contained in the partnership deed by issuing a notice under section 21 dated 17/2/2026 proposing the name of a sole arbitrator. Full stop. The said notice was admittedly received by all the respondents. Full stop. The respond number 1 by reply dated 2nd of March.
On page 50.
2nd of March 2026 agreed for the reference of the dispute to arbitration, though objected to the name of the sole arbitrator suggested by the petitioner. Full stop. Since no consensus could be arrived at between the parties regarding appointment of the arbitrator, the petitioner has filed the present petition before this court. Full stop. Learned Counsel for the respondent number 1 does not oppose does not dispute the partnership deed or the arbitration clause as contained therein. The same is with respondent number 2, 3, and 4, who does not dispute the partnership deed as well as the arbitration clause as contained therein. The parties consent to the appointment of an arbitrator in terms of the said partnership deed as well as the said partnership deed. Full stop. In view of the same, this court appoints Mr. What would be the dispute?
Yes, my lord.
Mr. Imtiaz, what is the dispute?
But the dispute is
How much would be the dispute?
but they have alleged that certain amount of money.
It's around
has been-
15 lakhs.
Just allow me to
Suggest a name.
certain amount.
Suggest a name.
I'll suggest a name. But what I can find from the notice which was replied from my learned friend, one name was he's my.
Forget about that name.
That cannot be done. So,
Any junior member, my lord.
Give a name.
my lord, junior member of
the
my lord, Shukanto Chakraborty. He's Shukanto Chakraborty.
Give the details.
Yes, Bar Association.
Mr. Shukanto Chakravarti is appointed as the learned sole arbitrator to adjudicate the dispute between the parties. It is made clear that the parties have consented to the appointment of a sole arbitrator instead of a arbitral tribunal consisting of 3 members, as contemplated in the partnership deed. The learned arbitrator shall enter reference in compliance with section 12 of the said act he shall be entitled to his remuneration in terms of the post schedule of the said act or with the consent of the party. A copy of this order shall be communicated to the learned sole arbitrator to take necessary steps. With the aforesaid direction, the present petition stands disposed of.
But the details, the mobile number and the not only thing, your lordship will record that I have
All issues pertaining to arbitrability, maintainability, limitation, or any other issue shall remain open to be adjudicated upon by the learned sole arbitrator.
it's an unregistered partnership deed, notarized.
Take all your defense.
I'm grateful. I'm deeply obliged. I'm grateful. এই নামটা দিয়েছি একটু দিদি মোবাইল নাম্বারও দিই
14.
But I was telling my learned friend, extremely embarrassing, my lord. Because that service in USA, my lord, that Wakalatnama which was coming from USA. It has been dispatched, my lord, but we still haven't received it.
How much time do you think you
But
can track it?
I think it should come by next week.
By next week. You can see the track report. The tracking can be done.
Yes, my lord, the tracking. We are looking at the tracking.
You become amicus, so. Sir, you become the amicus and you do that.
But then you will lose if I become a amicus. Legal points are against.
We'll have it next week then.
Mine.
On the safer side, then keep it on the 9th.
My lord.
My lord, would your lordship consider, my lord, recording that my friend is seeking time and that?
Then it also for the respond number. Mr. Bose,
6.
respond number 6. State that he has still not received the
Wakalatnama.
Vakalatnama. He seeks and is granted. He states that the Vakalatnama has been duly signed by his client and been
I trust you.
sent across. So the same has not been received by him. He seeks and is granted time to file the same before the next date based on.
My lord, if I may just point out, my lord, even respondents numbers 1 to 5 were to, my lord, file their wakalat.
He has filed their Vakalatnama and we are that has been
Great.
That was the last one.
But I am appearing for the petitioner, my lord. Very interesting point.
I appear for respondent number 1, my lord. There was a direction to file affidavit in opposition. I have served within time, my lord, but there is a mistake on my part. The original which is to be filed before, my lord, that is in a separate folder. It's in my office. If my lord takes the matter at 2 p.m., my lord, I can bring, or Monday, whenever, my lord.
Monday.
My lord, may I file my reply, my lord?
Yeah.
Oh, the opposition is not there.
Number 2, if I may file my You file it on Monday.
No, then it has to be
I'm
served. We have not filed it.
Monday. Sir. Serve a
Malad,
copy.
may I say this, Malad? Malad, kindly keeps it on Thursday. I'll point out why, Malad. I didn't have a reply to that their affidavit as yet, Malad. So I'll take some time. Malad, if your lordship kindly fix it on Thursday, then or Malad, the Monday thereafter, Malad.
Lordship, I appear on. Then you will take your time to file reply, no?
No, I want to file that reply and then it can come.
But the reply is not on record.
No, I have her reply. I have it with me.
Okay.
But Mr. Mitro's reply, Malad, is not ready. So if he's intending to file an opposition,
Let it come on record.
Malad, let it come on Monday, Malad.
Lordship, I appear on behalf of respondent number 3, Lordship. I have not received a copy of the application. The petitioner may serve a copy of the Section 11 application. Respondent number 3. Respondent number 3.
Serve Koroni? We had, I'll give him another copy, Malad. Malad, if he can just disclose who is
Hemant Tiwari. Advocate on record.
Hemant Tiwari, Malad.
Advocate.
Malad, makes a direction, Malad, if you lordship kindly just for a service.
Counsel for the
Respondent
respond
number 3,
number
Lordship.
3 states that he has not received a copy of the petition. The same shall be supplied to him
Today, Malad, we'll serve
in the course of the day. Based on Monday.
Malad. Grateful, Malad.
Monday.
Grateful.
Monday.
Happiness. 16.
Service is complete.
Yes. Yes, ma'am.
We have received payment in this one. Page 74.
Have you got the other?
Order.
Similar order? Similar order, right? When was the payment received? After the 21, right?
Yes, Lord. In 2022. June 22.
That's on 17.
Yes.
Serial number 17, right?
Yes.
Okay.
Which one? I'm the black card. I'm the black card. This shop. 17.
My lord, I appear for the petitioner, my lord. This is an application taken out in a section 11, my lord, application to record the death. My lord, the learned advocate had pointed out that the respondent number 2 has died, and a consequential amendment just to, my lord, bring on record the heirs, my lord. My lord, the death certificate, my lord, which was given to us is at page 8 of the, my lord, application. My lord, the respondent number 2 had died, my lord, Ashok Chatterjee, on 28th of April 2026. The spouse's name is, my lord, mentioned here as Bijoli Chatterjee, and they had given us also the particulars of the son and daughter who are surviving the respondent number 2, which is at page 9. This was, my lord, handed over to us. And my lord, the amendment, my lord, proposed amendment after recording of death is, my lord, at page 10, my lord, striking out of the name of, my lord, respondent number 2, and, my lord, 2A to 2C are the, my lord, heirs who have to be, my lord, brought in.
I appear on behalf of the 2A to 2C.
2A to C.
Yes, ma'am. Legal years of the.
No objection to this application. Take up. There is an application filed by the petitioner seeking amendment of APCOM 525 of 2026 to record the death of respondent number 2, Mr. Ashok Chatterjee, and to bring on record his
original
legal, his heir and legal representatives. It appears from the record that the petitioner had originally instituted the present application under Section 11 of the Arbitration and Conciliation Act, seeking appointment of an arbitrator to adjudicate the dispute arising out of the development agreement dated 30th November 2005. During the hearing on 17 July 2026, it was brought to the notice of the court that respondent number 2 had expired on 28/4/2026 prior to the institution of the present proceedings. Full stop. Learned advocate appearing for the respondent had furnished the death certificate of respondent number 2 along with the particulars of his legal heirs and legal representative. Full stop. By order dated 17 July 2026, the petitioner was granted leave to take necessary steps for bringing on record the legal heirs and representative of the deceased number 2 on record. Full stop. The petitioner now seeks to amend the cause title and the body of the application to record the death of respondent number 2 and to implead his legal heir and legal representative, namely his son Ayan Chatterjee and his daughter Payal Chakrabarti and the wife, right?
Widow, yes, my lord.
And the widow Bijli Chatterjee as the legal heirs and legal representative of deceased respondent number 2. The proposed amendment is consequential upon the death of respondent number 2 and is necessary for the proper and effective adjudication of the application under section 11 of the Act. Full stop. The amendment does not appear to change the nature or character of the proceedings or introduce any new cause of action. Full stop. In view of the aforesaid, the application is allowed in terms of prayer B, right?
My lord, prayer A is to, my lord, record the death, and prayer B and C is, my lord, amendment.
Prayer B. Full stop. The petitioner shall carry out the proposed amendment in AP Form 525 of 2026 within a period of 2 weeks from date. The petitioner is directed
To serve the amended copy.
directed to serve the amended copy to the substituted respondents. The department is directed to carry out the consequential amendments in the record and cause title upon compliance by the petitioner.
Grateful, my lord.
The aforesaid direction, the present application stands disposed of.
Is it my lord's pleasure to, my
Respondent
lord,
number so and so appears for the respondent, the newly added respondent number 2A, 2B, 2C.
A, B, C? My lord, two weeks time we have sought for to carry out the amendment, which we shall do. My lord, is it my lord's pleasure that after 3 weeks the section 11, my lord, comes?
After 3 weeks.
Grateful, my lord.
Become 525 data disposed. Amendment allowed. 18.
My lord, Mr. Sanjay Mukherjee is currently out of station. I'm praying for 1 day accommodation.
Not today.
Great.
19.
Lordship, this is my application under section 11, your lordship. The disputes between the parties have arisen out of a development agreement, your lordship. There's a specific arbitration clause between the parties, which lordship will find at page 31 of my application, your lordship. Now, lordship, there have been several incidents in the interregnum, especially with regard to conversion of the land, where there has been a stop work notice from the...
What is your objection?
Lordship. Lordship, it is time-barred application, Lordship.
Time-barred?
Yes, Lordship.
How is it time-barred?
Lordship. Agreement took place in the year 2004, Lordship.
Yes.
And thereafter, there was a clause that the development procedure will be completed within 18 months from the date of application from the getting sanction plan, Lordship. They never applied for the sanction plan, Lordship. Lordship, in the year 2025, Lordship, they have referred the matter. They have
section 11 time barred. Madam, we are not concerned. As far as your limitation and other things are concerned, go before the arbitrator, argue it out.
Lordship, if Lordship, but
Tell
it
me
is
how the section 11
agreement
time.
when the agreement doesn't have any existence. When the agreement doesn't have any existence,
Doesn't
Lordship.
matter. Even if the agreement has no existence, go before the arbitrator to claim all that.
Then I am the worst sufferer, Lordship.
All I need to know is, madam, whether there's an agreement which you have entered into or not, containing an arbitration clause.
Lordship,
the rest of the dispute, go before the arbitrator.
Yes, Lordship. Lordship, Lordship, may I?
Please do. Yes.
Paragraph 64 onwards. Reference.
Yes.
2024 5 SCC 358.
Lordship, page
Yes.
64, paragraph 64 onwards, Lordship. Lordship, when the arbitration, Lordship, when the limitation starts, when one party,
Limitation starts, madam, if your section 21 notice is beyond 3 years.
Lordship, section 21 notice, but if anybody sat tight of any matter, Lordship, without giving the section 21 notice, it is also time barred, Lordship. It is time,
It's
Lordship.
not time barred. With the
Lordship,
new,
kindly see once the paragraphs, Lordship.
lot of, after this also there are a lot of judgments which have come, madam.
Lordship, yeah,
Please have a look at Krish spinning.
Lordship, Bidya Dolia is also has been considered by Lordship. Lordship, when the when I came to learn clearly that there is a refusal on the part of another party for this clause, Lordship, I came to learn that that there is a dispute between them. I should have referred the matter before the arbitration. I sit over the matter tightly. I didn't take 20 years, Lordship, 20.
Go and argue all this before the arbitrator.
Then
Not before me.
But Lordship, then I have to suffer. I have suffered that I have to include.
Recover. File a counterclaim. You will not suffer. File a counterclaim against her. File a counterclaim. Get more money. You will not suffer.
After
in section 11, I can't decide this, madam.
But
Sorry.
Lordship, the agreement took place in the year 2024.
Yes, file a counterclaim stating you have suffered. Quantify your claim on terms of your suffering.
I have to bear the expenditure of the arbitration proceedings also.
Recover it. Recover more money.
It is also suffering, Lordship.
Recover. That's why I'm saying file a counterclaim. File a counterclaim.
If your Lordship wants to see the paragraphs, Lordship.
Yes, I will. Yes,
Lordship knows that there are subsequent judgments, Your Lordship.
yes, I know. That's why I was
Lordship
pointing it out. to
Bokui,
her.
then Aslam Ismail Khan, all of 2025, Your
All
Lordship.
2025. That's what I'm telling you. Go before the arbitrator. Raise all your contentions are open. If you are challenging the execution of the development agreement, then I'll give you time to file your reply. If you are admitting the execution of the agreement
But
and
when
the
the
clause,
agreement is itself
Adam,
in the condition of non-existence.
go and argue before the arbitrator. You're not denying your signature. You're not denying the execution of the agreement. Yes, where is the agreement? Page.
Lordship, page 31 of my application, Your Lordship, is the arbitration agreement. Lordship, clause 21.
Yes.
Lordship, a sole arbitrator is contemplated. Lordship, my primary claim will be of specific performance.
21 notice.
Lordship, 21 notice, Lordship, is of 25th of August 2025 at page 61 of my application. Lordship, I have nominated a learned advocate,
This was
learned senior advocate of this honorable court, Your Lordship. They have also given a reply,
page.
Lordship, at page 70. Lordship, the first portion of the reply is absolutely on merits, Your Lordship. Lordship will find their reply at paragraph 10, Your Lordship, 84, the relevant portion so far as this proceeding is concerned. Lordship, page 84, para 10.
Take. First, I obtain that the present petition has been filed under Section 11(6) of the Arbitration Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the development agreement dated 26th of March 2004. Full stop. It is the case of the petitioner that the said development agreement was executed between the petitioner's firm AS Construction, as developer, and one Shrimati Lakshmi Saha, the owner of the subject property. Full stop. According to the petitioner, the respondent subsequently became the absolute owner of the property by virtue of a gift deed dated 27th November 2014. It is alleged that the petitioner was ready and willing to perform their obligation under the development agreement, and the respondent failed to take necessary steps for conversion of the land from inverted comma में करना Danga to Bastu the inverted comma, and had thought to deal with and create third party right in respect of the property, giving rise to the dispute between the first. It is the case of the petitioner that in terms of the partnership, in terms of the development agreement, clause 21 of the said agreement contains a valid arbitration clause, and the petitioner invoked the arbitral proceedings by issuing a notice under section 21 dated 25/8/2025, whereby the petitioner had suggested the name of Mr. Arindam Banerjee as senior advocate as the nominee arbitrator. Full stop. The respondent had replied to the said notice and had declined to accept the said nomination, refused to nominate an arbitrator on his behalf, and disputed the validity of the invocation notice. Full stop. Consequently, the parties failed to constitute an arbitral tribunal in terms of the arbitration agreement. Full stop. Learned counsel for the respondent does not dispute the execution of the development agreement, neither the arbitration clause as contained in the said agreement. Full stop. This court is of the Brahmasudha view that when the said agreement as well as the arbitration clause is not under dispute, this court is there. Full stop. It is therefore submitted that this court ought to exercise its jurisdiction under section 11(6) of the Arbitration and Conciliation Act by appointing an independent sole arbitrator. In view of the same, this court appoints so and so as the learned arbitrator to adjudicate the dispute between the parties. Full stop. All points related to arbitrability, maintainability, claim, counterclaim, or any other issue shall remain open to be adjudicated upon by the learned arbitrator. Full stop. The learned arbitrator shall enter a reference in terms of section 12 of the said act. Full stop. He shall be entitled to seek his remuneration in terms of the first schedule of the said act or with the consent of the parties. With a copy of this order shall be communicated to the learned arbitrator to take necessary steps. Full stop. The present petition is disposed of in terms of the above directions.
Looks extremely grateful, Your Lordship. No,
You have any name to suggest?
No. Anybody, Your
Lordship,
Lordship.
anybody, Your Lordship so desires. Lordship, I think the parties cannot come to a consensus on.
Anybody, Your Lordship. Is 2 kata 8 cheetahs of land, Lordship. Anybody, Your Lordship, fit and proper.
Lordship, absolutely.
Have any suggestion here?
Lordship, any one of the.
Anybody, Your Lordship.
Huh? Okay.
All right.
Any of them. Grateful, Your Lordship.
Yes, sir.
20. This is my application. My husband was the owner of the premises
Yes.
that was acquired by National Highway Authority for widening of road.
It's appearing on the other side, sir.
Yes, a percentage deduction I have served copies.
That's all right. I understand you have.
Affidavit of service. Affidavit of service is also there.
Who's appearing? I know affidavit service is there. Who's
কেউ
appearing?
অ্যাপ্লাই করে জানিস? সার্ভিস হয়েছে? Service was affected.
Where's the track report? Where's the service? How is the service affected? Where's the track report? There's no track report. Give it to him.
Oh, sorry.
Just make a statement. Service is affected.
But it has been served. I have seen it,
Very
but
nice.
that should have been, track report should have been annexed to this.
How will I see it, sir?
Yes, that is true. Sorry for this.
Not today.
সোমবার দিনে নিয়ে
Give back the service report. So that
Yes. Service report done. Service report 21.
May it please, Malad, I'm appearing for the respondent, Malad. I'm
may I-
appearing for the respondent, Malad. Malad, I'm yet to seek instruction, Malad, because yesterday I've been marked with the matter for the union. Malad, because I was seeing the clause, Malad, I'll be very candid, Malad. There is, with respect to a constitution of a dispute adjudication board, Malad.
Adjudication board, forget about all that. You come back with the
Yes,
instruction.
Malad. I'll have to just come back with the instructions, Malad, because the clause mentions 3 arbitrators.
No,
Lords, may I just seek my lord's attention to page 146, my lords?
Yes.
They have not disputed the arbitration. The only thing is they seek our waiver under section 12, subsection 1, my lords. And immediately after that, we have said that we cannot give our waiver.
What is it? DRB? Dispute Resolution Board. What is it?
Their own, my lords, they have a panel of arbitrators, my lords. And I refer to 2 judgments, my lords. We say
Know that judgment.
my lords, the railway, my lords, just one point, my lords. The rail
Instruction.
correct, my lords.
Come back with the instruction.
Yes, Malad, I'll come back with the instruction.
Disputing the arbitration.
No, Malad, there is no dispute with the arbitration clause. It's because the clause says 3 arbitrators on this dispute. They sought for 1, Malad. I'll take instruction and come back.
The Honorable High Court has appointed single arbitrator, my lords.
Can't appoint a single arbitrator unless until the party agrees.
Lords, we do not
clause
have a
64
problem with the arbitrators as well, my lords. We do not have.
Let him come back with the instructions.
Obliged, man.
Wednesday.
Obliged, man.
Grateful, my lords.
22.
My lord, this is my application under section 11, my lord. All the respondents has been served, my lord. They have received it. I have served them with mail also, and they have received all the respondents, my lord. My lord, this is my lord, identical to that matter, my lord, on August 19th. Yes, my lord. My lord, I have just marked a little bit, my lord.
Just made the corrections.
Yes, my lord. Apologies, my lord, I have done it. Here they have made few installments, my lord, and the objection was directly made to the arbitrator, my lord, so that there is no letter of that. Otherwise, it's similar, my lord. Junior member will appointed. Yes. Much obliged.
This is a section 11. I'm sorry. Sir.
This is a section 11. My lord, I must be candid, my lord. This is a section 11 where a non-signatory party also, based on the Cox and King principles, my lord, wants to be implemented, my lord, in a part of a larger arbitration matrix.
I am taking a preliminary point, my lord.
So, my lord,
21 notice has not been
one minute, let me.
the party.
I am only indicating, my lord. I'll do the matter next week, my lord. I don't want to do it today. All the judgments have not come. I don't want to waste. Kindly keep it next day. Not today. Just makes it not today, my lord. I just come with a note so that it will be easy.
In that case, my lord, I can use an affidavit to indicate why I am saying this.
My lord, he had indicated on the last day he would not file affidavit. That is why it was kept. If he wants to use it, I have no problem. Let him.
Very good.
If he wants to file affidavit, I have no problem. My lord,
that I should
No,
file.
no. You are only saying that. Otherwise, I am only asking not today. I am only asking not today.
Well, only thing, my lord, what I would like, I can indicate to my learned friend, my lord, my point of maintainability so that he can address your lordship on that.
Yes. That let him do it.
Lordship will kindly take once the notice which he is relying upon. What could be that?
Yes.
Kindly.
But after I open my case, I think it is
better for you.
Or very well.
Very
well. If he wants to, I don't want to stand in the way.
Just give pointers.
Yes, it's just a pointer.
Just pointers so that he can address on the next day.
Yes,
Don't
yes.
waste my time, Mr. Singh.
Kindly take page 290.
Actually, it is assistance to him, not to me.
Okay.
Just give me the pointers.
What I बोला this?
I'll-
He'll inform to me outside the court. I don't want to waste the court's time because he's doing a favor to me.
Your lordship will just say, my lord, the maintainability.
Yes.
Everything is.
Lordship is.
For
Lordship
our
is.
purpose.
I'm not doing.
But a one-liner for our purpose.
Learned counsel for the petitioner. And I have to record the petitioner has filed the present application under section 11(6) of the Arbitration and Conciliation Act seeking appointment of a the sole arbitrator, right? Sole arbitrator.
Sole arbitrator, yes.
In terms of the dispute and differences which have arisen between the parties in connection with the loan cum hypothecation agreement dated 15th March 2019, personal guarantee agreement dated 15th March 2019, corporate guarantee agreement dated 15th March 2019, and the rupee facility agreement dated 5th March 2020. Full stop. Learned counsel for the respondent at the outset takes the point of maintainability. Let this matter be listed on next week.
Any day, whenever first day lordship, whenever lordship takes up these matters, my lord, Wednesday or whenever lordship takes it up.
9th of September.
Lordship.
This helps in the billing.
Yes, Lord.
Helps. Who's the client?
Yes. For our purpose, my lord.
May it please your lordship, my lord. This is my application under. This is my application under section 11. A learned friend is appearing, my lord. Though may I file the affidavit of service?
Section 11.
My section 11 arising out of a partnership agreement. My lord, the agreement is dated 2nd January 2007. Lordship will find that at page 15. 1.5. And the arbitration clause, my lord, is at page 23, clause 20.
Page 23.
Page 23.
Page 23.
This is item number 24.
This is item number?
Item number 24. Yes, it is 659.
It's 23 or 24?
24.
41.
It becomes 659.
No, you are looking at the affidavit. I have separately annexed the arbitration agreement.
Yes. This is 20.
Arbitration agreement only.
This is part of an separate annexure. Kindly see the separate annexure. Well, there's some discrepancy with his copy. I'm just pointing out page 23, which is the arbitration clause. This clause 20 is the correct copy. It's also separately annexed in a different place. My learned friend was looking at it from there. My lord, may I tell you your lordship the facts in a nutshell? My lord, the petitioners and the respondents. Dada, may it please your lordship.
Yes.
My lords, may I tell your lordship the facts in a nutshell? My lord, the petitioners and the respondent numbers 1 and 2, they are there was a partnership firm with the predecessors of these people. They are the legal heirs. The petitioner number 1 and 2 is the legal heir of one of the partners. The petitioner number, the respondent number 1 and 2 is the legal heir of the other partner. My lord, the partnership deed contemplates that it is a partnership at will, and upon the death of one of the partners, it will continue. The legal heirs will be substituted and a reconstituted partnership deed will be executed. If I may take your lordship through two clauses of the partnership agreement. If your lordship kindly comes to page 20, clause 10. May I place the clause, my lord?
Yes.
That the constituted co-partnership firm shall run at will of the partners and may be dissolved by any of the partners by serving 6 months notice in writing upon the other partners. The partner shall, however, be entitled to retire upon 3 months notice in writing upon the other partners, and receipt of such notice. An account shall be taken of all assets and liabilities of the co-partnership firm to determine the capital balance of the retiring partner, which sum shall be refunded within a reasonable time. So it's a partnership at will. The next clause, my lord, is what I rely on, that the death or retirement of any of the partners shall not have the effect of dissolving the co-partnership business, but the co-partnership firm in such an eventuality shall be carried on by the surviving and or continuing partners, the legal heirs and or representatives of the deceased or retiring partner, and also by the admitting outsiders with full advantage as to the licensees, permission, sanctions, etc. So, my lord, it provides that on the death of a partner, the partnership will continue and the legal heirs will be substituted. Now, my lord, the petitioner number 1 and 2 are the legal heirs of one partner who passed away in the year 2020. Previously,
Wait a minute. What? Which date?
my lord, 11th December 2000.
All the petitioners over here.
The petitioners are the legal heirs of
the earlier partner.
Earlier partner. May I take your lordship to the cause title?
Just to make it cut short, my lord.
Lord, may I place,
all
my
these
lord?
partners and all these, they are family members. It's a family business.
Yes.
They have suppressed here that regarding this family business, a suit is already pending, filed by them, and that is for partition. In that suit, we had filed an application to add this business, which they have not added, and other properties also, as a part of the same hodgepodge. Now, after that, this is the subsequent application that they have came up with. The application herein is almost regarding that we are not getting the profit percentage as a partner, and we are to be included as a partner. My lord, kindly come to the affidavit page once.
Page?
Page 13. My application. Kindly see, my lord. I am Meenakshi Roy, wife of Shyamolendu Roy, age about 70 years. By faith Hindu, by occupation housewife. A person for 70 years was a housewife, will now be a partner and will control the business.
My lord, may I?
And the other lives in Switzerland. She doesn't live here. and whether she is getting his profits or not. My lord, I would like to place their income tax.
Let me place my case. You will get your chance, sir. Milord. Milord, firstly, Milord, on the fact of suppression, kindly comes to para 6, page 5 of my petition. The suit that my learned senior friend is talking about was the suit filed by my predecessor. A partition suit has been instituted by late Shyamolendu Roy, being title suit number such and such, before the City Civil Court. The partnership firm is not a subject matter of the pending suit. There can be no partition of a partnership firm. Moreover, the parties are bound by the arbitration agreement contained in the partnership firm. That is number 1, Milord. If required, I'll produce the necessary documents. Kindly, Milord, comes to para 15 of my petition. Page 8. Lordship has page 8?
Yes.
The respondent number 1 herein filed an application under Order 7, Rule 11 in connection with title suit number such and such. In March 2025, Milord, this is where my knowledge arises from. March 2025, the respondent number 1 filed a supplementary affidavit disclosing the deed of partnership. Milord, the petitioners were not engaged in the day-to-day business of the partnership firm. It was run by, Milord, which is why, Milord, I wanted to take your lordship to the cause title. Meenakshi Roy, wife of late Shyamolendu Roy, and Rituparna Roy, daughter of late Shyamolendu Roy. The wife and the daughter, who are the legal heirs, are the petitioners before your lordship. They were not engaged in the partnership business before, because it was a partnership of both brothers, which is not the subject matter of the partition suit, because that deals with family properties through inheritance. They have kindly, sir, please, let me kindly place my case. Order 7, Rule 11, they bring up the partnership deed. From there, this is, I'll take your lordship to that. I have annexed it, Milord. Kindly comes to page 26. Milord, on the top left corner of the page, there is a date on which I have received this, 20th March 2025. This is a supplementary affidavit to the Order 7, Rule 11 filed by them. Milord, these are all tribal issues, whether my initial contention is partnership firm has to be dissolved. It cannot be partitioned. The partnership assets cannot be partitioned. And Milord, it's governed by the Partnership Act, number 1. Number 2, legal heirs of a partnership firm are entitled to enforce the arbitration clause. Milord, your lordship knows, Supreme Court has also said. So today, Milord, they are not disputing the arbitration agreement. Kindly allows me to place this supplementary affidavit, after which I'll go to the demand notices and my section 21. Page 26, at page 27, paragraph 6. This is their supplementary affidavit to the Order 7, Rule 11 filed by them in the suit. So there is no suppression. I am bringing all the facts before your lordship. That there was a partnership deed between Shyamolendu Roy, me, and with my brother, the defendant number 3, Shri Anirban Roy. I have referred to the partnership deed, but due to inadvertent mistake, it could not be annexed. Copy of the partnership deed is annexed. Now, Milord, this is 20th March 2025. As I've shown your lordship, that is the day I've received. That is the day from where my knowledge arises of the existence of the partnership deed and the entitlements that the partners and their legal heirs have.
Kindly take a note of it, my lord.
Kindly take a note of this, Milord.
That they didn't have any knowledge.
Now, Milord, kindly come to page 43. This is my demand for accounts, to furnish a copy of my accounts and urging the fact that the partnership will be continued by the legal heirs. Milord, at page 44, the second paragraph, third paragraph, starting with it is material. It is material and relevant to note that prior to reconstitution of the said partnership firm, which was documented on 2nd January 2007 under a deed of partnership, the said partnership business was being run by the two brothers. These are, Milord, the predecessors of the petitioners and the respondent numbers 1 and 2. The last two paragraphs, my lord, as per the agreed terms of the said partnership as recorded under clause 11, which I had placed before your lordship, in the event of death of any of the partners, the partnership business would be carried on by the surviving and or continuing partners and the legal heirs and the representatives. In strict adherence, next paragraph, we being the legal heirs of Shyamolendu Roy have stepped into the shoes of the deceased partner. My lord, there is no reply to this letter. This is 1st August 2025. The next letter is 2nd February 2026. Again, no reply on the same point. Then, my lord, on 18th May 2026, I issue the Section 21 notice. My lordship recalls the partnership deed was available with me only after March 2025. Thereafter, on May 2026, I have issued the Section 21 notice. Their reply, my lord, is at page 67.
Your
They
notice is-
contain.
Your notice is 56, right?
My notice is page 56. I am grateful. I have invoked, I have nominated, and then the reply. Now they reply for the first time. And the arbitration agreement is not disputed. The disputes, my lord, are apparent on the face of it, and the existence of the arbitration agreement is not denied. Well, these are my contentions. My lord, I have certain judgments to rely on, if your lordship pleases, on those 2 points, that the partnership asset.
Happened after that. My lord, their notice and everything surrounds to that they were unknown that a partnership deed is there, a family business is present. Place of this business is the place of residence of the petitioners. On the second floor they reside, on the first floor the business go. But she didn't have any knowledge. Even if I believe it, my lord, this is of
Knowledge was, my lord, only one thing with respect to the partnership deed and the contents.
Very good. Very good. This is an income tax of Meenakshi Roy of 2023. She didn't have any knowledge till 2025. I had only one copy, my lord. Kindly see, of Monindo Textile, she is getting 50% of his profit, of her profit. Meenakshi Roy থেকে না? Meenakshi Roy থেকে না?
Yes.
She had suppressed this. And the reasons of now, my lord, of 2024, she is again received 50% of the profit. These are income tax copies. Now, 2025, she has again received. In relation, we call him Jetima. A 70-year-old lady will not come into day-to-day affairs. And the girl who resides in Switzerland will also not come in day-to-day affairs. If they want to be partners, they have to join with day-to-day affairs. If they are ready, if they undertake to do that, we have no problem. There is no need of any arbitration. The accounts are very clear. Anytime. It is submitted by them only. Now, if he wants her name, we have no problem, my lord. But she have to come in day-to-day affairs. She have to go in the fields to sell the products. Will she do that? If she undertakes that?
That's not the scope of Section 11, sir.
This is the reason. There is no need of anything. If they want, we are agreed
You
to make
tell
them
me-
enter in this. Their only problem is that,
Answer the query to the extent of section 11.
Lordship, their only need is that we want to join the business. We have no problem in it. Let them join it. And regarding the accounts, anytime they can see, they have all.
Point is not to
So
join
no
the
arbitration is
business.
required.
They have filed a section 11 to raise all these issues before the arbitrator. I'm not here deciding your issues or your family dispute. For that, the partition suit is already filed.
Yes.
You tell me
And
how
these are all
this is-
part of the partition suit.
Oh, sir, you tell me how this is not maintainable.
This is not maintainable. Well, there are two reasons.
Yes.
One, the parties have agreed to the Arbitration Act 1940.
So,
that's a repealed one.
Yes.
Secondly, these all subject matters are before the civil court in a partition suit where the orders are pending.
Say that.
Now to frustrate that, they want to get into the arbitration.
You file your reply, get all that.
I will file.
Take down. The present petition has been filed under section 11(6) of the Arbitration and Conciliation Act 1996, seeking appointment of a sole arbitrator in terms of clause 20 of the partnership deed dated 2nd January 2007. Full stop. The petitioners are stated to be the legal heirs of late Shamlendu Roy, who was a partner of Mahindra Textiles. Full stop. The respondent number 1, 2 are the sons of Shri Bimlendu Roy, the original partner. Full stop. Upon the death of Shri Bimlendu Roy, the partnership was reconstituted by a deed dated 2nd January 2007, under which Bimlendu Roy held 50% share and the respondent number 1 and 2 held 25% share each. Full stop. It is the case of the petitioner that after the death of Shri Bimlendu Roy, the petitioners, the legal heirs of the petitioners, seek to participate in the affairs of the partnership firm and had sought the inspection of the accounts and other financial records. Full stop. According to the petitioner, the respondents had failed to cooperate and had retained exclusive custody of the book and accounts of the petitioners of Mahindra Textiles. Full stop. The petitioner allege that despite repeated demands, they have not been able to procure the said documents from the respondents. Full stop. The petitioner further states that he had issued a notice under section 21 of the Arbitration and Conciliation Act dated 18th May 2026, invoking the arbitration in terms of the clause mentioned in the partnership date dated 2/1/2007. Full stop. Learned counsel for the respondent disputes the learned counsel for the respondent states that the present petition is not maintainable since the proceedings that since the petitioner had already filed suits before partition suit before the city civil court. City civil court. Full stop. He seeks and is granted how much time? 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. 1 week or 2 weeks?
1 week. 1 week.
1 week thereafter. List after 6 weeks.
Grateful.
May I have the copies of that?
Yes.
I will put it in the records for their.
My lord, I beg to appear on behalf of the petitioner, my lord. This is my application under section 11. There are two respondents. They have all been served. My lord, after service, my lord, talks of settlement have transpired between the parties. My lord, kindly adjourn the matter for 2 weeks' time, my lord. We
Learned
shall
counsel for
come
the
back.
petitioners states that settlement talks are underway. He seeks an adjournment. Let this matter be adjourned for
For a fortnight time.
2 weeks.
Lord, may I kindly record that they have been served. My lord, I have given the
Affidavit of service taken on record. Despite service, none appears for the respondent. Uske baad kya? The learned counsel for the petitioner states that settlement talks are underway. He seeks an adjournment. Let this matter be adjourned for a period of 2 weeks. List after 3 weeks.
After?
3 weeks.
26.
Well, at 26, I appear for the petitioner. It's coming after we have served. My learned friend is appearing for the other side as well. Well, it's section 11, Millard, praying for appointment of an arbitrator. The arbitration agreement is dated 1st December 2024. Your Lordship will find at page 15, and the arbitration clause is at page 19. We have given a section 21 notice, that is 27th of July 2026. That's at page 76, Millard.
Are you opposing the?
But as far as the formalities are concerned, my lord, I have no objection. But my lord, I fail to understand what is the dispute.
No,
Where it is stated, my lord, what is the dispute?
I don't want to adjudicate I don't want to address the disputes here, but I just
Statement of claim.
I just wish to point out, Millard.
They have to make out a case asking for a dispute and differences occurred between the parties in respect of the agreement.
So they have a remedy under section 60.
I have a claim.
Millard, may I just only point one thing?
Let me. Once I lodged a claim before them, I made a police complaint in consecutive 2 occasions asking for demanding the amount.
There was some election going on in your Tirumali flat owner.
Yes, Millard, this is one of the premium residents of Calcutta.
It's a residential flat.
There
was one more matter. Who was doing it? You were doing it?
No, Millard, I was not doing it. Millard, I'm not aware of this. Millard, I just wish to point one thing, Millard.
Because the parties, they said that the parties will change because there's an election which is going on.
I'm not aware of any such information, Millard. I'm sorry. I am unable to address my lord on this. I just want to, Millard, point
My
one
concern
thing.
is, my lord, I have provided security service over there. And I have a claim as of now is 9,40,000.
Very good. You file a counter claim.
But that's not a problem, my lord. But I fail to understand, my lord, what is the dispute? That's, my lord, they have referred this matter.
Section 21.
21 notice only your lordship sees.
Let's see. Where is that?
Millard, it's at page 76. I believe there is no reply given by my learned friend.
No reply.
What is the issue?
The issue, Millard, there are various issues that, Millard, they are a security guard company who provides security guards. They have not maintained the standards that were arranged, that were agreed to. There were various deficiencies, this, that, all that has happened. To that, they have raised a claim of 9 lakhs. We have said that, no, you're not, nothing is due and payable. On that account, disputes have arisen. Millard, I just wish to point one thing, that the sum involved in this litigation, Millard, is not over 10 lakhs. So, my lord may kindly, Millard, appoints a junior member of the bar, Millard, in this matter.
As far as, my lord, appointment of arbitrator is concerned, my lord, I have no say on it. But, my lord, as per their notice, what is, my lord, the dispute that is required to be arbitrated?
So the dispute, if my learned friend wants to know, what is the dispute, my lord, kindly comes to page 82. Roman 25 onwards, my lord, all that there's a difference between the parties so far as claims and counterclaims have been mentioned.
Where is the claim? I can believe that I have a claim.
Yes,
Claim.
that is what I'm saying, that you don't have a claim. So
I have a claim.
Aha. I'm denying your claim. This is what I'm saying. That is the dispute.
No, I have not approached before my lord. I ought to have been. But anyway, my lord, I'm not standing on the way.
But let me just kindly choose as a junior member of the bar. This is what my instructions are.
Good for you. You don't have to but section 11.
Rather than cut down my expenditure.
I'm aiding my learned friends.
Let it be.
Intention. Yes.
The petitioner has preferred the present petition under section 11(6) of the Arbitration Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the work order number, page 12, work order number so and so, dated 1st December 2024, full stop. The petitioner is an association of flat owners of a building known as, inverted comma, Tirumani, situated at Waliganj, Calcutta, full stop. The respondent is engaged in the business of providing security guards and security management services. Full stop. Pursuant to the work order dated 1st December 2024, the respondent was engaged by the petitioner for providing security management services at the said premises. It is the case of the petitioner that the respondent was required to deploy the requisite number of security guards and supervisors and to maintain the standard of security and services as stipulated in the work order. Full stop. According to the petitioner, the respondent failed to comply with the contractual obligations, including deployment of adequate and trained security personnel and maintaining the security at the designated post and ensuring proper shift management. Full stop. Learned counsel for the petitioner states that despite repeated reminders, the respondent failed to curb the deficiencies, rectify the deficiency as pointed out by the petitioner. Full stop. The petitioner finally, did you terminate it?
Well, it's terminated.
Yes, my lord, it's terminated.
Page.
My lord, that letter, my lord, is not there.
Well,
But
it's
my
on
lord,
mail.
14th
It's
May.
on mail, my lord.
Annexure C, Annexure 20C.
Annexure, my lord, the C.
Consequently terminated the contract by email dated for. It's there, sir. You don't even
Yes, my
see
lord.
a brief.
I'm sorry, my lord, I missed. I'm sorry, my lord, I'm sorry.
Your brief and you have not even seen it.
I just missed, my lord, I'm sorry.
You're so busy, huh? Busy counsel.
No,
Too many
no.
briefs to handle. 14th May 2025. Full stop. The petitioner invoked the arbitration clause as contained in the said work order by issuing a notice under section 21 dated. What is the date of the notice?
27th of July, 2026, my lord, at page 76.
7th of July 2026. Did you respond?
No, my lord.
Full stop. The said notice was not responded by the respondent. Full stop. The learned counsel for the respondent states that he has no objection to the appointment of the arbitrator. Full stop. The work order as well as the clause containing the arbitration appointment of the sole arbitrator is not disputed by the learned counsel for the respondent. Full stop. With the consent of the parties, Mr. Give a name. Yes, give a name.
My lord, Mr. Varun Kothari, my lord, Bar Library Club. He can be appointed, my lord.
Mr. Varun Kothari, give the details of the concerned. He is appointed as the sole arbitrator to adjudicate the dispute and differences that have arisen out of the work order dated 1st of December 2024 between the parties. Full stop. All issues relating to limitation, arbitrability and all that left open. 12.
Grateful, my lord, extremely grateful.
All right. Mr. Monday. Monday. Come back on.